Welcome to this 2021 Legislation and Policy Update webinar. This video explains how recent legislative changes resulting from the Government of Alberta's implementation of Bill 47, the Ensuring Safety and Cutting Red Tape Act, in early 2021. This webinar will provide you with an overview of the legislative changes specific to egregious conduct, highlight your responsibilities, and provide you with the resources to help keep you informed about this change. A detailed overview of the other legislative changes and the Duties Cooperate legislation are provided in other webinars in this series. Egregious conduct is new legislation effective January 1st, 2021 for all claims regardless of the date of accident where the egregious conduct occurred on or after January 1st, 2021. This policy was open for consultation in early 2021. Policy was posted on April 1st, 2021, and will be applied retroactively for any claim with egregious behavior occurring on or after January 1st, 2021. New legislation added a new subsection to the Workers' Compensation Act that may affect the benefits WCB pays an injured worker when the employer withdraws or terminates modified work. Previous policy and legislation required WCB to put the worker on full wage loss benefits when an employer withdraws or terminates modified work. This new subsection provides an exception to that rule if the removal or termination of modified work resulted from the worker's egregious conduct. Instead, WCB will pay benefits as if the modified work was still in place. So if the worker was completing full-time modified duties with unreduced wages, WCB will not issue any further wage replacement benefits. If the worker was working 4 hours a day on modified duties and WCB was paying 4 hours of wage replacement benefits, the WCB would continue to pay the 4 hours of wage replacement benefits and not top up the missing hours. If the worker has a permanent work restriction, WCB will review their entitlement to wage benefits at that time. The worker could go back on a full wage benefit while participating in reemployment services or be entitled to a monthly top-up benefit. It is important to note that the claim will remain open and the worker will still be entitled to medical aid and other appropriate benefits. We have included the section of the Act and relevant policy for further reference. Egregious conduct is defined as flagrantly bad or staggeringly bad or obviously wrong beyond any reasonable degree. This definition of egregious conduct is based on Canadian case law. There is a high threshold when deciding if the conduct was egregious. Behavior such as breaching company rules is bad and will probably warrant disciplinary action. But only behavior that is outstandingly or flagrantly bad meets the definition of egregious conduct. Several examples of behaviors that may be considered egregious conduct will be discussed in the upcoming slides. When determining whether behavior qualifies as egregious conduct, WCB will consider whether a reasonable person from society at large, knowing the behavior and the context in which the behavior occurred, consider the behavior shockingly bad. Some situations that may involve egregious conduct are a breach of an employer or professional safety standard, rule, or policy, violence, including aggressive, threatening behavior, sexual harassment or assault involving coercion, threats, or violence, deliberate destruction of property, fraud, or embezzlement. Each situation is unique and must be evaluated independently. For example, an employee stops a robbery from occurring at the job while they're completing modified duties. This is against the employer's policy. But is this egregious? Likely not. Although it is against policy, it's a fairly normal reaction in a stressful circumstance, and the worker was trying to protect their employer's property against a theft. In another example, a worker is on modified duties and decided to steal a company truck. When confronted by coworkers, they appeared intoxicated and threatened them with a pitchfork. RCMP were involved. Is this egregious? Likely yes. It was deliberate, intentional act, and they endangered others with their potentially criminal actions. Keep in mind that this policy applies to an employer removing modified duties due to egregious conduct and is not used to determine claim acceptance. Please reference Policy 0201, Part 2, Application 5 for further information on a worker's actions that remove them from the course of employment applicable to claim acceptance decisions. If you're considering withdrawing modified work on a temporary or permanent basis, or terminating a worker due to behavior you feel is egregious, please contact the WCB. The claim owner will review the information to determine if it meets the requirements outlined in policy. As this is new legislation, we will review these decisions at a management level to ensure consistency. We do not anticipate there will be many claims that meet the high standard of the egregious definition. Some factors we consider when determining egregious conduct are: if impairment was involved, did it make the worker physically and mentally incapable of performing their duties? Was the conduct a deliberate, intentional act or an unintentional error? What are the policies that are not being followed? What were the actual or potential consequences of the conduct? Did it endanger the worker or others and/or cause injury or property damage? Are there mitigating factors? Remember that the WCB's decision is made only for the purpose of applying the legislation. It does not affect the employer's ability to set company policies or its right to discipline its workers for actions that are contrary to those policies. Here's how we will make the decision. The first question we ask is, would a reasonable person think this behavior is shockingly bad? We may gather additional evidence to help determine the nature of the egregious conduct. Specific evidence could include, but is not limited to, police reports, documented progressive disciplinary actions, witness statements, and employer safety documents. There are no penalties to the employer for termination under egregious conduct. This is just to determine if the worker is eligible for wage replacement benefits. We still need to look at termination reasons under the obligation to reinstate, if it applies to that particular claim, and/or duty to cooperate. In summary, please remember that the bar for egregious conduct is very high. There is a financial impact to the worker, as WCB will pay wage replacement benefits as if they are still performing the modified work. This only applies to temporary wage loss benefits. And if it is determined that the worker has permanent restrictions, WCB will review for reemployment entitlement. In making these decisions, WCB is not questioning the employer's policy. We are determining whether the worker's benefits will be impacted. If it is decided that the worker's conduct was not egregious, we will review the claim to ensure the worker met their duty to cooperate. We hope this presentation helped with your understanding of the egregious conduct legislation. Let's conclude with a brief discussion of available resources. You can stay informed and get updates when changes like these happen in the future. WCB's website is updated regularly. Visit our legislative changes page to continue to stay informed. You can download fact sheets which explain these changes and view the policies that guide our decisions. You can also sign up for our email newsletters and receive important business updates straight in your inbox. To sign up for policy notifications, view current policies, and to provide comments and feedback on open consultations, visit our website. Simply search for "What's New in Policy." We also provide numerous other virtual seminars at no charge to you. Please check out the seminars and workshops page on our website and register. WCB now has a new employer app to make it easier for you to pull clearances, check your account balance, and make payments, update your account, and to contact us. Check it out in the Apple Store or on Google Play. Thank you for watching the webinar. For more information on the duty to cooperate and other legislative changes made in 2021, please view the other webinars in this series.